All right, good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, March 6th, 2026. We are on voting list number 6. We're going to get it on there. Voting list number 6. We're going to start off with Senate Bill 16, and Shamari is counsel for that.
Senate Bill 16 limits an earnings wage withholding order from exceeding 25% of an obligor's disposable earnings for the combined support order and arrearage if the obligor's individual income for the current year does not exceed 250% of the federal poverty guidelines, unless the obligor was determined to be voluntarily impoverished at the time of the most recent order. An earnings wage withholding notice sent to an obligor's employer must include information relevant to the bill's limitation. The bill also authorized an employee to contest the amount of withholding order based on the limits specified in 10-129 of the Family Law article. Disposable earnings means that part of the earnings of an individual remaining after the deduction from those earnings of any amounts required by law to be withheld. There is an amendment in your packet. It's Amendment 613623. And the amendment hasn't finished going through review, but I can explain it if.
Yeah, is that why there's no interlineating?
Yes.
Can you please, yeah, please.
Okay, so the first amendment is to strike from the bill amendments to section 10-122 and 10-128. And we substituted 10-129A, and that is, you can read that on page 1 of the amendment text, and it provides that except as provided by paragraph 2 of this subsection in the Federal Consumer Protection Act, on receipt of a copy of an earnings withholding order or earnings withholding notice, an employer shall, beginning with the next pay period after receipt of the earnings withhold order or earnings withholding notice, deduct the amount of the withholding from the obligor's earnings on a regular basis, and send the deducted net amount directly to the state disbursement within 7 days, not including Saturday, Sunday, or a legal holiday, after day on which the earnings are paid to the obligor. The amount deducted under paragraph 1 may not exceed 35% of the obligor's disposable earnings if the obligor's disposable earnings for the current year do not exceed 250% of the federal poverty guidelines for a family of one, unless the obligor was determined to be voluntarily impoverished at the time of the most recent court order. So the changes that we made were essentially to place the onus on the employer as opposed to the Child Support Administration. That was after discussions with our work group and with certain stakeholders. And so we raised the amounts, the maximum amounts that may be deducted to 35%. And that deduction or that limit would only apply for obligors making 250% of the federal poverty guidelines for a family of one. We added that clarification for a family of one, and currently that puts the annual income at around $39,000 that the bill's protections would apply.
How much would it monthly? How much would it monthly be?
I didn't do that math.
700, 600.
I want to thank council and sponsor and the other members of the work group and the individual that came in to explain it. I was, yes, I was concerned about this bill, but now I understand it is only applying to those with 250% or more of the federal poverty line. So as council said, those who are only making $39,000, that the goal is to get them to pay. The goal is to get them to pay some amount rather than no amount. And then I also understand that we're not just talking about the amount that they owe monthly, but also the arrearages that they have been accumulating. And to address that, I think this bill makes a lot of sense. It doesn't, to the best of my knowledge, I just want to confirm, it doesn't relieve them of any of the obligations that they have, the child support or the arrearages, but it just deals with the deductions from their wages. So with all that, I just want to say thank you to everybody that worked on this.
There is a fiscal note, which is about 3.8 million in fiscal year 2027, but the amendments are intended to address that large fiscal note by instead placing the onus on the employers to deduct the required amount as opposed to the Child Support Administration having to essentially figure that out. And my understanding is that employers already do that, and employers are the person that's charged with making sure the deductions comply with the federal limits of 65%. And so the discussions in the work group were that would be the most appropriate person to have to make that deduction amount.
Did the business community get consulted, or they're fine, or not?
My understanding is the stakeholders were in consultation with DHS, and they are the ones that provided the amendments, and so that's the basis of.
Senator James.
Just a couple points of clarification. So this bill does not conflict with our child support guidelines because it isn't about capping the obligor's limit of what he owes for the person owes for child support. It just caps one particular way. You can capture some of that income through garnishment. Is that correct?
That is correct. So the child support order is separate. The court will set that amount as appropriate, and then the employer is the party that garnishes.
So nothing in this bill, if legal aid or the individual themselves or the mother or father of the children that is getting the support on behalf of the children, that nothing limits them from pursuing back child support or having other assets attached in some way, or how does that work?
So the payee of the child support would have all of the means available by law to still pursue the order.
And so this would, so in other words, the court wouldn't even be aware of this when they're issuing like a child support order and determining amount, which many of us have worked on for decades to make it work, make it be fair. And, you know, the primary purpose, the sole purpose is the best interest of the children. So this does not in any way conflict with that goal of ours and those guidelines?
Yes, this bill does not touch the child support guidelines.
And do we have any idea, two more questions. Do we have any idea about how many children are affected? And the only way I could think of doing that as a snapshot would be if we had a sense currently, because you can't predict the future, of, you know, where most obligors or parents that are paying child support, if they're in this limit of 39,000 and below, right? It's 39,000 and below, is that right?
Yes.
Okay.
Okay.
Do we have any sense of rough estimate of how many children have parents that have that, you know, the obligor parent has that income?
So Center of Urban Families talked to us at the work group, and the 35% that we amended it to would account for approximately 94% of child support orders. Mr. Dews is present, and Mr. Turner from Center of Urban.
Yeah, sorry, I just got. So did you understand? I just want to know if we do this, how many, for this moment, we're in, I realized then they could be different. How many children or families, or however you want to do it, will be affected by this bill?
So I don't have the exact number of families. I'm happy to follow up with that.
Sure.
What I want to make sure you know to your earlier questions is we bumped the number from 25% to 35% specifically to make sure that this would not conflict with the percentages at which the guidelines set orders compared to incomes. So 95% of child support orders are at 35% or less of the obligor's income.
That's what I thought too.
Yeah.
So, okay. And then you or whoever would like to, what is the stated goal? You know, from my perspective, as I do family law.
Sure.
What I most want is to make sure children get the child support they're entitled to, and with all due respect. a lot of parents have to pay that child support, do not want to pay that child support, or do elaborate things to avoid having to pay that child support. And it's an awful, awful way to try to protect children. So what's the goal of this?
Sure.
And how does it, and can you say, and how does it protect the best interests of the
Sure. This is, at its core, a bill that will increase collections. And it will increase collections because the current garnishment rates drive low-income obligors out of the workforce.
You mean so they go and get paid under the table?
Exactly.
Or things like that?
And wage withholding is the most effective tool in, as I'm sure you know, Senator,
Yeah.
wage withholding is the most effective
Yes, it is.
tool to collect and disperse child support payments. And so when individuals run to the underground or black market economies because they literally can't afford to feed themselves, we lose the ability to withhold their wages.
So that's interesting, and I hope that's true. I don't hope it's true, but I hope it's true if we pass this bill. So, and again, I'm sure there might have been some testimony, but this has happened in a few other states. I assume we're not the first state in the country to do this.
So other states have capped it at 50%, and some states for even more poor people have capped it much lower. So we'd be the first state to cap it at 35%, but just to complete it, this is based off the former head of child support for the Feds' recommendation. She actually recommended 25%. With feedback from both Senator Charles and the administration, we bumped it to 35% to make sure we covered folks.
I should have asked a longer question, because all I wanted to know is not so much this was identical, but that other states are doing that, because the real question I have is, do we have data that shows what you said just a little bit earlier, that this will stop people running into the black market to get paid under the table? Do we have data to show we get greater compliance and more child support to the children that need it? That was really the question.
Got it. Yes, ma'am. So there's sort of three different sets of research you have to combine to drive this. One is there's an entire body of research that shows once you garnish once your child support orders are set at higher than 25 to 35% of a person's wages, collections don't increase, right? So we already know there's only so much people will pay.
Okay.
The second piece is there's research that's done by ADP as part of their business services that show for non-child support collections with garnishments, it drives down withholding. It drives down employee retention. And so that's things, all the other ways is you might have debts.
Maybe you can send that to me later. That's interesting. Okay,
so
got it.
those are capped at 25%, and those drive folks down. So you can only imagine what happens at 65%.
And then the third one, you said there was one more?
The third one is qualitative data analysis that has happened over the decades of researchers interviewing low-income non-custodial parents, and those low-income non-custodial parents telling them, when I can't afford to feed myself, I have to find other means and do what I can. And then, we support and have been supporting low-income. Fathers are primarily the non-custodial parents, as you know. So we try not to say fathers, but it's largely fathers, right? But supporting low-income non-custodial parents over the 26 years of work, we do know that they tell us all the time, I had to quit. I couldn't afford rent. I couldn't feed myself. When my child asked me for extra things when they were hanging out with me, I couldn't afford to buy them.
Thank you very, very much for that. I appreciate it.
Thank you for your questions.
So I'd like to move to adopt the amendments, and then we can have further discussion. Is everyone okay with the amendment being adopted? Okay. Further discussion on the bill as amended? We did. We just did. All right, there's been a motion for favorable. It's been seconded. Do we need a roll call, or is everyone okay being?
I got to vote now.
Okay, so we're going to do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden. Senator James.
No, and let me just say, I hope the people behind this bill are right. I hope this results in better collections and protecting children. but because of my own work in this area, I can't support this in good faith. I hope the data comes along and supports everything you're doing, and if not, I hope we will repeal this and do something that's more effective and fair to the children. Thanks. So my vote's no.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
Yes.
Senator Charles.
Yes.
Senator Folden.
Yes.
Chairman Smith.
Yes. 10-1. We're now going to go on to Senate Bill 38. Is that you, Shamari?
Senate Bill 38 specifies that an individual must participate in the ignition interlock system program as a condition of modification of a suspension or revocation of a license or issuance of a restricted license if the individual violates an alcohol restriction imposed under Title 16 of the Transportation Article. Currently, only individuals younger than age 21 are subject to this requirement. Consistent with existing statute, if such an individual fails to successfully complete participation in an ignition interlock system program, the individual is subject to a 1-year mandatory license suspension.
All right, there's a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill. That was easy. All right, Senate Bill 38 passes unanimously. All right, we're now going to go on to Senate Bill 352. Is that?
Can we skip this one?
Yeah, can we pass?
We pass.
All right, so then we're going to go on to Senate Bill 354.
Senate Bill 354 increases the minimum gross income amounts from charitable contributions above which a charitable organization must include a certain audit or review with a registration statement. The bill increases the threshold for an audit from $750,000 to $1 million, and for a review from $300,000 to $500,000. The bill further authorizes the Secretary of State to accept certain documentation in place of an audit or review in connection with the charitable organization's registration statement if the charitable contributions do not exceed $500,000, which is up from $300,000, and amount to 20% or less of the total gross income.
All right, there's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 354 passes unanimously. All right, we're now going to move on to Senate Bill 482.
Senate Bill 482 alters an existing offense to prohibit a person from intentionally, willfully, and without authorization committing a violation of 7302 of the criminal law article, which is unauthorized access to computers and related material. This offense would apply with the intent to interrupt or impair the functioning of critical infrastructure or a public safety answering point. Violators are guilty of a felony and subject to existing penalties of imprisonment for up to 5 years and/or a $25,000 maximum fine. The bill also establishes a new offense by prohibiting a person from intentionally, willfully, and without authorization committing a violation of the underlying offense that denies access to an authorized user of, or interrupts or impairs the functioning of critical infrastructure or a public safety answering point. The new offense is a felony punishable by imprisonment for up to 10 years and/or a $50,000 maximum fine. There is one amendment in your voting packet. which is SB 482, 653-226. This alters text on bill page 5 and would alter the new offense to instead prohibit a person. It would provide a person may not intentionally, willfully, and without authorization commit an act prohibited under this subsection that denies access to an authorized user of, or interrupts, or impairs the functioning of critical infrastructure or a PSAP. So this is essentially adding that that mens rea to the new prohibition. It also adds it just above in line 3 of page 5 to the existing prohibition.
Well, so let's adopt the amendment. So there's a motion to move to adopt the amendment. It's been seconded. Okay, now the bill's before you as amended. Further discussion. Okay. Motions for favorable has been seconded. Is everyone okay being recorded in the affirmative? Yes. Okay. Senate Bill 482, as amended, passes unanimously. All right, we're going to go to Senate Bill 819. Is that you? Yep. Okay. Take your time, though.
Senate Bill 819 requires that a county or municipality, when filing a complaint for an in rem foreclosure action on specified vacant property, serve the complaint on each interested party in accordance with the Maryland rules. This requirement replaces an existing requirement that the county or municipality within 5 days after filing the complaint send notice and a copy of the complaint to each interested party by first-class mail and certified mail, postage prepaid, return receipt requested, bearing a postmark from the U.S. Postal Service. The bill takes effect June 1st, 2026.
Yeah, motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? It's an easy one. All right, Senate Bill 819 passes unanimously. We go Senator. We're going to go Senate Bill 140.
Thank you. No, that wasn't, I was actually clearing my throat. Sorry. The Senate Bill 140 generally prohibits a person from committing the crime of benefits exploitation. A violator is guilty of a felony and on conviction subject to a penalty of imprisonment for up to 25 years and or a $15,000 maximum fine. There is one amendment in your voting packet. The amendment is SB 140/653-127/1. This provides for graded offenses, or graded penalties rather, for the offense. Would provide that if the aggregate value of the money or other goods or services is less than $1,500, the maximum penalty is 1 year and or $500. If it is at least $1,500 but less than $25,000, the maximum penalty would be up to 5 years and or $10,000. Further, at $25,000 but less than $100,000, $1,000. The maximum penalty would be 10 years and/or $15,000. And then if the aggregate value of money or other goods is $100,000 or more, this would be a felony subject to up to 20 years and/or $25,000.
Adopt the amendment, and then, so the amendment is adopted. Now the bill's before you. Senator Love has a question, and then we're going to go to Senator Sidnor.
Thank you, Mr. Chair. I like how this is broken out by tiers. I'm just questioning the penalty structure. We just passed a bill when someone intentionally, willfully commits, they impair the functioning of critical infrastructure, and that's only 10 years. So now we've got something for someone who defrauds of a lot of money, and I get that, and it's awful, but that's 20 years. So I just have a question about the parity of our penalties.
So we have a commission that is studying this whole issue. It's, whenever a bill establishing criminal penalties is introduced, there are an infinite number of existing crimes that you could try to compare it to. And that's what this commission is doing. So I think the better thing would be to relegate this, along with all the other criminal cases, to the commission that's trying to organize these things in a logical way, rather than try to deal it on a one-off basis. We could deal with every single suggested criminal act on a one-off basis and compare it to any number of other criminal acts out there. We should do it in an organized way rather than in a one-off way.
I absolutely hear you, and that was my thought. I'm glad to hear that there is a commission. When will this commission have their findings, and who's
I'm
on
hopeful
it?
by the end of the year. We extended the life of the commission so that it's supposed to give us a report by the end of the year. And I know it's working actively.
Great. Thank you.
Sure.
Thank you.
If I completely agree with that. I mean, you got misdemeanors that have greater sentences than a lot of felonies, and a lot of collateral consequences that come with any sentence for longer than 2 years. I mean, it's all over the place. But if just for comparison, can you pull up the general theft statute and the tiered structure for penalty?
Sure. So under 7104, the criminal law article, Maryland employs a general theft statute that similarly grades the penalties based on the value of the goods or services that were stolen. So under that provision of law, for at least $1,500 but less than $25,000, a person would be subject to 5 years and/or $10,000. Between $25,000 and $100,000, maximum penalty of 10 years and/or $15,000, and $100,000 or more would be subject to imprisonment not exceeding 20 years and/or $25,000.
So let's go to Senator Sidnor. I saw your light was on. And then to Senator Henson.
Thank you, Mr. Chair. I wanted to thank the bill sponsor for his diligence in working on it. At the bill hearing, I did raise a question about subsection B2. It's a broad range of offenses that are included in the bill. It goes all the way from kidnapping an actual person and trafficking that person to obtain their benefits, all the way through simply receiving funds that come from those benefits. And I raised the scenario of, what if you are a dependent spouse and your spouse is the partner that you're financially reliant on, and you know that your spouse is doing that, but you don't have a means of earning income for yourself. And that's your spouse's way of obtaining income, is fraudulently obtaining the benefits of other people. And under the bill, we give the ability for that financially dependent spouse to be sentenced for a crime under the bill. And so in that conversation and trying to make sure that there was a penalty structure where the felony option and going forward with, you know, a 25-year sentence, that there was some sort of alternative. And I get it. The structure that we put in place in the amendment, it ties it to the level of the benefit that was obtained, not necessarily the degree to which you are criminally, you know, culpable or the egregiousness of the crime that you committed. But it does, I think, signal to the court that the intent of this bill is to have some measure of gradation in terms of the spectrum of offense that is listed in the bill, that there should be some spectrum in terms of the sentencing for whatever a person's offense is as it's listed. So I just want to thank the sponsor for being responsive to that concern that was addressed and working out an amendment that shows to the court that we want to make sure that if a person is sentenced under this, that there is some consideration for that. So I do appreciate it. Thank you, Mr. Chair.
Actually, I think that conversation was very good, but also worth memorializing and putting it into the bill file, so that there was, I mean, this is part of the legislative history as well, but I mean, reducing something to writing and putting it in the bill file could be helpful. So, all right. So now the bill is before you as amended. What do y'all want to do? It's a motion for a favorable. It's been seconded. All right. Do we need a roll call, or is everyone okay being recorded in the affirmative? All right. Yes. Senate Bill 140 with the amendments passes unanimously. Senate Bill 516.
Senate Bill 516 prohibits a law enforcement agency from assigning a law enforcement officer to duties other than administrative duties unless the officer is issued protective body armor. It also establishes requirements for the issuance and replacement of protective body armor and establishes provisions relating to the failure of a law enforcement agency to replace protective body armor as required by the bill. Specifically, in circumstances where a law enforcement agency does not replace expired body armor, there would be reporting requirements to both the Police Training and Standards Commission and then to the Governor's Office of Crime Prevention and Policy, which could result in the withholding of grant funds to the law enforcement agency. There is one amendment in your voting packet. That is Amendment SB 516-133-825/1. This would make changes on bill page 3 and line 3, which is the one of the grant fund withholding provisions, and it would provide that a law enforcement agency could provide proof that they had purchased or issued replacement protective body armor to, and therefore not be subject to the loss of funds. Or it would also provide that the Governor's Office of Crime Prevention and Policy may not withhold from a law enforcement agency under that specific subparagraph grant funds specifically designated for the purchase of protective body armor. I just want to clarify that that's an and. You could avoid the loss of funding by showing proof of purchase, and the loss of funds under just that one provision wouldn't apply to grant funds that were designated for the purchase of protective body armor.
All right, everyone's okay with adopting the amendment. Now the bill's before you as amended. So Senator James has a question.
I asked the vice chairman, and he said it would be okay if I asked to be amended on as a co-sponsor. I think it's a really great bill. So if that doesn't mess up our schedule, that's what would be my request.
You know what? I'll jump on it as well. How about that? There you go.
Thank you.
All right.
Everyone could jump on.
All right.
Okay, hold on. All right, so I have James, Smith, Henson, who else? Love, West.
Folden, McKay.
Everybody but Nick Charles. His support is law enforcement.
Muse is on. Nick Charles. Oh.
Charles
Oh,
is on.
shame.
Okay,
All right. So,
so it's everyone except for Senator Sidney.
okay. He's
You wanna be
on.
on?
All right, so he's
Okay,
on.
so now it's everyone.
Everybody, the whole committee's on. All right. There you go. Kumbaya. All right, so Senate Bill 516 with the amendments passes unanimously. All right, we're gonna go back to, no, okay, no, we're not. Okay.
Yeah, it was.
Okay, so last week we passed, or 2 weeks ago, we passed Senate Bill 101, which is the loan repayment and scholarship expansion for correctional officers. That was cross-assigned to Triple E. They amended it. Every member of the committee amended themselves onto the, to the bill. Well, most of them amended themselves onto the bill. So it's back here with that amendment. We have to approve that amendment and send it out. So we are on the bill. Well, I don't know who's on the bill from the
No,
committee.
but if we add co-sponsors.
Then
it
it's
has
got to
to
go back.
to
So
Triple E, and then we're
just do a
gonna
floor
have to-
amendment at
yeah.
this point. Let's get it out of the committee structure first. So, so there's a motion for a favorable with the amendments for Senate Bill 101. It's a bill we passed unanimously out of this committee. Is everyone okay being recorded in the same posture as they were before? Okay.
Well, Senator Waldstraker and Senator Muse were not here.
So, but they are okay
they're
now. Yeah.
good. Yeah, okay.
All right. So Senate Bill 101 with the amendments passes unanimously. We're going to jump down to Senate Bill 437.
Senate Bill 437 prohibits a person with the intent of defrauding another from altering or tampering with a gift card as defined in the bill or its packaging. Violators are guilty of a misdemeanor subject to imprisonment for up to 18 months and/or a $500 maximum fine. The bill also establishes a valuation method for gift cards for purposes of the theft statute. There is one amendment in your voting packet. That is Amendment SB 437, 743-225/1. That makes changes on page 3 of the bill. Would alter the valuation provision. Would provide that the value of a gift card is the greatest of the highest value listed on the gift card or its packaging, or $100 if no value is listed on the gift card or its packaging. The value of the gift card could also be the value of the gift card or gift card redemption information that a person obtains from a gift card holder or a gift card issuer through a false or fraudulent means. Finally, it could be the amount of loss incurred by any person involving the use of the gift card. So it would be the greatest of any of those three. like it just got a hearing yesterday, so it hasn't.
Senator, before you document the Senator Lowe.
Thank you, Mr. Chair. Can you explain what the language "in two" means? Because I'm sorry, I don't understand the amendment for 2 Roman numeral 2.
Roman 2. So that would be, this next reads the value of the gift card or the gift card redemption information that a person obtains from a gift card holder or gift card issuer through false or fraudulent means. So my reading of that is that if there is a gift card holder kind of presents I know what a gift card issuer is. A gift card holder, I'd be less clear on, but to me that means that you're getting information about the value from either of those 2 sources. It does seem to complicate it a little bit that it needs to be through false or fraudulent means. I'm not really sure why it would limit the limited in that way, because it sort of suggests that that section or that that item doesn't apply unless there weren't false or fraudulent means in obtaining, that information.
Yeah, I find this, I'm not quite sure what we're trying to get at, and I'm really confused by this, because this says to me, if I obtain a gift card fraudulently, I don't know, it just seems to say that if there's fraud involved, then you can claim the amount of that gift card?
So I can't speak to the wording, and I wasn't here for the hearing, but I was the victim of this scam. It was a small amount of money. And so I can kind of explain a little bit. It's a complicated fraud, what's happening, but their organized crime goes into places where there are gift cards and obtains like the code for the gift card, but doesn't obtain the value until someone purchases that gift card and activates the gift card. And then the organized crime ring somehow, upon the activation by the consumer, then receives the value of that gift card because they have the code. So they don't have the physical gift. I think what this wording is doing, and I may be misunderstanding the nature of the fraud, is that I'm the card holder. I purchased the card, but because they previously got like the code, when I activate that card, they receive the value of the card, even when they don't have the physical card. And so that's what I lost, whatever, $50 on this. And what's interesting, and this doesn't relate to the wording, is that the card providers don't care that, that this is happening, that their cards are being misused, and provide no security on the cards, because whether I buy it or the fraudster gets the value of it, they've already got their money. And so one of the weirdest things is that the fraudsters and the card providers, they're not in cahoots, but they essentially have the same incentives here.
So it sounds like from what you're saying, we're getting at when there's a range in value, so like a card that could be up to $100 and you redeem it for $50?
So, yeah, I'm sorry. So they because they have the code for the value, I determine the value of the card when I purchase it. When the fraudsters obtain like the code, they don't know how much I'm going to place on the card.
Right.
So they have in advance arranged for whatever value I purchase to essentially go to them. That's what happens. So when I purchase the card, it says how much you want to purchase, put on this, and I put $50. The fraudsters originally had the code. They then get the $50, but they did not know in advance the range that I was going to put on the card.
Right. So that seems to me to be addressed with the highest value listed on the card, if it has a value, so let's say up to $100 listed on the card, or if no value is listed $100. I'm just not sure what 2 is getting at.
I think Roman 3, because it would be an amount of loss incurred by any person involving the use of the gift card.
So why is number 2 necessary? Is what she's asking.
Right. I'm not entirely sure, because I think that 3
Captures everything.
does capture everything.
It captures the gulf between what is actually taken. That's what I'm saying. But let's go to centerfold. Is this responsive to this, or is it something else?
It's in regards to this. I just wanted to give clarity. I mean, the Senator Waldstreicher's right. I mean, this is just because of the scheme. So that people are taking the cards, they're documenting the info in their computer, and as soon as it's activated, it's automatically delivered to them. So that's the scheme. The $100 valuation, in my opinion, from what I understand, was because there's anything under $100 value, because it's available up to that, but anything under that value is basically like a criminal citation, I guess. And if they don't have that, like, it puts it into the category to where there's, as far as tracking it, I guess, to quantify or qualify to the misdemeanor amount, not a civil issuance of citation, because the combination of the scheme and the amount of the fraud. So I don't know if
Right.
that clarifies or makes it more muddy.
I get all that, it just doesn't get to, yeah.
I don't care.
This amendment, have we yet? Let's adopt this amendment. Okay, is everyone okay adopting the amendment? All right, so then there's another amendment, which is to strike, it's in between lines 11 and 12, but number 2, right? Number 2, under Roman 1.
Right. So that would be,
So can you just see how it would read?
the new language would read, the value of a gift card is the greatest of, Roman 1, the highest value listed on the gift card or its packaging, or $100 if no value is listed on the gift card or its packaging, or 2, the amount of loss incurred by any person involving the use of the gift card.
So what I don't want to do is, that's the lowest level that's available for a charge. I just want to be clear on that, and when we're talking about this, they're not always going to be right in front of you for the arrest. There's an investigation that transpires here. So what I think we're losing is that the lowest amount, because if you take, like, you know, I think at this point, I would rather just hold the bill, because it's important for me to be able to clarify for you guys to understand that the $100, if you take a bunch of them, the $100 is the minimum that's in the actual charging manual for a crime. It's a misdemeanor. So below that, it becomes a civil, you know, it's a citation.
I don't think it impacts the $100 as a floor. What the bill is saying, yeah, even with that amendment, is that whatever out of those 3 categories, either the amount that's represented on the packaging, the $100, or the most that somebody lost, you're always looking to the greatest of those 3 things.
So what you're saying is, nothing's marked on the packaging.
Right.
It's going to be $100.
Right.
By what you're saying in number 3.
Yeah. So
That's what I'm looking for.
let me sort of like run that. If something is marked on the package that is less than $100, so let's say it's a $25 gift card.
Right.
It says $25. Then obviously that $100 threshold only applies, or that $100 floor only applies where there's no marking on the gift card.
Right.
But otherwise, if, let's say there's nothing marked on the gift card, but somebody's actually out $500 because that was the personal loss that they sustained. You're not even going to look to the $100. You're going to look to the $500 because that lead-in language says in line 10, the value of the gift card is the greatest of. So any of those amounts that are in play.
Okay. Okay, that's fine. That's fine. We can move it now. We can move it now.
Now the bill's before you with the amendments. Motions for favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill Senate Bill 437 with the amendments passes unanimously. All right, so on page 3, we have Senate Bill 717 and Senate Bill 737 are both withdrawn. So the motions for withdrawn, is everyone okay being recorded in the affirmative for the withdrawn bills? All right, both are unanimous. All right, we're going to go to Senate Bill 745.
Senate Bill 745 requires the Maryland Police Training and Standards Commission to require for entrance-level police training and as determined by MPTSC for in-service level training conducted by the state and each county and municipal police training school that the curriculum and minimum courses of study include, consistent with established law enforcement standards and federal and state constitutional provisions, training regarding individuals with dementia and autism, including training for locating an individual who is wandering, eloping, or otherwise missing, searching near bodies of water, sensory-aware approaches, reunification, documentation, and interagency coordination. There is one amendment in your voting packet. That is Amendment SB 745, 583-624/1. That makes changes on bill page 2 of 2. It would change the existing training requirements. Under existing law, there's a requirement for training regarding individuals with physical, intellectual, developmental, and psychiatric disabilities. This would actually strike those existing requirements as they exist now and incorporate them into the new language. So the new language would read, training regarding individuals with intellectual and developmental disabilities, dementia, and autism, including training for, and then those 6 items that I mentioned before.
The amendment has been moved. Everyone has voted in the affirmative for the, okay. So the amendment stopped it, and then we have another amendment, sponsor amendment. Senator Love wants to be on, Senator Henson wants to be on, Senator Charles wants to be on, Senator Fold wants to be on, Senator Muse wants to be on, Senator West wants to be on, Senator Walsh wants to be on, Senator Smith wants to be on.
Golden Muse.
The entire committee is on.
Senator Sidnor?
Senator Sidnor is on. We're all on.
Thank you, everyone.
That's great.
MPJ is on?
Yep, she's on. Oh, yeah. Yep, just give it a second. Agree. All right, now the motion's for favorable with the amendments. It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 745 with the amendments passes unanimously.
And
All right, Senate Bill 160.
Senate Bill 160 is a departmental bill from the Department of State Police. Requires a licensed firearms dealer who knows or reasonably should know that a burglary, attempted burglary, robbery, theft, or any other event may have compromised required security features to notify the Secretary of State Police within 24 hours after the dealer first discovers that the security features may have been compromised. The required notice is in addition to any report made to the local law enforcement agency or the Bureau of Alcohol, Tobacco, Firearms, and Explosives. A violator is subject to existing penalties that apply to a failure to meet the required security features. There is one amendment, excuse me, there's not an amendment in your voting packet, but I have included a copy of the amended House cross-file. This struck the new language in the bill. It instead required that a licensed dealer shall notify the secretary within 24 hours after the dealer first has knowledge that there has been a burglary, attempted burglary, robbery, or theft involving a firearm or ammunition at the premises which the licensed dealer operates or where the firearms are stored, or two, a security feature required under that section has been compromised, including failure of equipment to film and record video footage, failure of a feature to prevent unauthorized entry, failure of a burglary alarm to allow for monitoring, or failure of a physical barrier to prevent a breach. As it states in the bill originally, the notice required is in addition to notice to local law enforcement and ATFE.
All right, so these are. Just want to make sure this is on the record. So the MSP worked on these in the House. Do you have any other context to provide? But I think we're good to go, unless people have questions. All right, let's adopt the amendment, which is not really an amendment, it's in concept.
Conform.
Conform it to the House version.
Right.
Yeah.
So it's to conform to House Bill 284.
Is everyone okay?
Do you want to repeat that on mic?
Sure, it's to conform the bill to House Bill 284 as passed by the House.
That's the motion. It's been seconded. Everyone's okay? Being recorded in the affirmative. Okay, now the bill is before you as conformed. The motions were favorable? It's been seconded. Is everyone okay being recorded in the affirmative? Okay. I'm sorry? Oh.
I don't think so. What?
All right, hold.
Okay with this bill? 160.
It's 160.
I think we need a roll call.
Need a roll call? If MSP would like to provide any.
In the House, we were asked to work with the opponents to make sure that the language was acceptable. So the SSF and Mark Pennick were the participants in the work group that we had, and we came up with a new language that passed the House.
Thank you. No, I understand now. Okay. We're going to do a roll call.
They were good with that language then?
Yeah, I just did.
Yes, they signed off.
We don't have a letter.
She's representing.
You're representing. Okay, thank you.
She represents state police, right? But I'm talking about the other people that were discussing.
Yes, I was asking if I don't think she represents the, Mr. Pennick, but you are confirming, that Mr. Pennick, if he were here today, would say, I worked with you all and I support or do not oppose the amendments, is that correct?
Yes, ma'am, I have the emails from both the lobbyists for NSFF and SSF and Mr. Pennick approving the language.
All right, great, that's what I needed to know, thank you.
All right, so it passes 10 to 1. All right, the next bill is Senate Bill 172. It's not on the, it's on me, that was not on the list, but it's 172, Senate Bill 172. We passed this last year, 10 to 1. But if the council can explain it.
Sure.
It's the method we've got.
Senate Bill 172 repeals provisions of existing law that require all assets owned by any Methodist church to be held in trust for the United Methodist Church and subject to the discipline, usage, and ministerial appointments of the United Methodist Church. The bill authorizes a local church to disaffiliate from the United Methodist Conference and retain ownership of its property, and finally includes provisions related to required reimbursements to the United Methodist Conference by disaffiliating local church for real property used by the local church.
Year. And what it does, when the United Methodist Church, when their governing body of all Methodist churches got together, they decided that they took a vote that churches could leave. Churches began leaving, and because so many left, they then came back and said, especially in this conference, you can leave, but you have to pay now half of the value of your building. Smaller churches, nobody could do that. Sometimes, and then they gave them like 3 months to do it, and if they didn't do it, then their request to leave would not be honored. So basically, where it says all property is held in trust, when they took that vote to change it, it really came in conflict with the statute that I'm trying to have removed. The other thing that they said, and I worked to make sure that at least that wouldn't be that issue, they said, what about churches that we put money into? What about, so then we amended it to say if there's any debt owed to the Methodist Church because they have invested money into that church, either physically or otherwise, then that they had to pay it back. The local church, before they left or disaffiliate, they had to pay it back. So that took care of that, which was one of their major concerns in the testimony that they gave. So.
I'm going to say to support Senator Muse. Yes, we heard this last year. Yes, I'm still waiting for the answer of whether it be HVAC, whether it be roofs, whether it be whatever. I'm still waiting from the Baltimore and Washington Conference of United Methodist Church of my question 2 years ago was please give us incidences. And I asked again this year, and I don't know, maybe my email's down, but I have not heard from them. So.
Am I correct that this wasn't on the voting list, so I wouldn't have, okay. So I apologize for this, but I did have my staff bring the file down, and I'm not doing an adequate job, but I do have a letter from the Attorney General, and from last year, which I had them confirm was still valid on January 27th. Now, not knowing what bill we're dealing with, what version of it, I do see that in the opinion, the AG is saying that at least one or more versions of this bill are, let me see, hold on, present a significant risk of violating constitutionally guaranteed free exercise rights. So I just want to put that in the record, but I don't know what version. I know we passed a bill out. I think that letter dealt with the version we passed. Then I think the House changed it, and I don't know where that stood, but I did want to say that without having the bill in front of me or any amendments, there was some constitutional questions, significant constitutional questions about the bill.
The House did not deal with the bill at all. They didn't deal with it because we ran out of time, so they didn't deal with it.
I would love to support Senator Muse on this bill. I am concerned about the taking of property without just compensation. It comes down to the question of whether the parent church owns these churches. And the statute was passed many decades ago saying they do, and now we're going to repeal that statute.
It was passed in '68, and if you look at the testimony, originally, Governor Mandel came in and said, yes, I signed it into law, and it was one of the worst.
It was the biggest mistake he ever made.
Yes, it was the biggest mistake he ever made, having his staff look back over it, that the issues that it just raised too many issues when they did it. Technically, the Methodist Church doesn't own the property. It says it's held in trust for United Methodist purposes. So that's different because all of these congregations, they have put their own, some of them are, from 1800s, they put their own money, they built their own churches. And as a question that you asked, they do pay 32% of operating expenses every year to the United Methodist Church. And that was choking them, especially from 2008 on, when people just didn't give as much as they gave. And so that's pretty much what it does.
I get all that, and I would love to. I'm going to abstain on this because I have a huge question mark about who actually owns these churches. And in light of my indecision on the constitutional aspects of the bill, the best thing for me to do is abstain.
Can I say this? No church gave a deed or deeded it to the Methodist Church, so they own no deeds. It says in the statute, it is held in trust by the United Methodist Church for Methodist purposes. So the congregation literally owns it. No church has turned over ever a deed to them at all. And so the question became, when they voted at their general conference in 2020 to say that churches will be able to disaffiliate, and hundreds did. Then in 2024, they changed it back and said there must be a fee to leave. So that really made that statute in so many ways, it was null and void. And that, for that reason, that's why I'm asking for a favor.
Vice Chair Waldstreicher.
For Anthony, yes.
Senator Sidnor.
Yes.
Senator West.
I abstain.
Senator Muse.
Pass. I mean, yes.
Senator Folden.
No. Sorry.
Senator James.
I think Senator Muse is one of the greatest senators. I love working with him. I truly I do. But now I've read a second letter from the Attorney General, which also says the bill and its many iterations have serious constitutional questions interfering with contract, interfering with property rights. I could abstain, but I think we usually should just vote one way or the other. So with all due respect to the senator, I'm going to vote no. All right.
Senator Henson.
Yes.
Senator Love.
I do have questions about the constitutionality of it, but for Senator Muse, yes.
Senator McKay.
Yes.
Senator Charles.
Yes.
Chairman Smith.
Yes. Passes 8-2. Okay, we're now going to move on to Senate Bill 215 because it's cross-assigned to EEE.
Senate Bill 215 generally extends applicability of certain provisions relating to local government personnel, trout stamps, and landlord remedies under tenant holding over actions to definitively include all members of the uniformed services. In addition to other clarifying and conforming changes, the bill also relocates the existing definition of a military protection order to the state government article. This was passed out of Tripoli unanimously.
Is motion for a favorable, it's been seconded. Further discussion before the vote's called. Everyone's okay? Is everyone okay being recorded in the affirmative? All right, Senate Bill 215 passes unanimously. We're now going to go over to Senate Bill 345.
Senate Bill 345 allows a dealer association on behalf of itself, a dealer, or a group of dealers to request a hearing with the Motor Vehicle Administration to either resolve a dispute between a dealer, a designated dealer successor, or a dealer association and any manufacturer, distributor, or factory branch, or to seek clarification or interpretation of any provision of applicable law. The opportunity to request a hearing does not apply to a dispute involving a manufacturer, distributor, or factory branch that does not have at least one franchise dealer in the state. Dealer association, as defined in the bill, means a business entity that is primarily owned by or composed of dealers that collectively represent a majority of the franchise dealers in the state and primarily represents the interests of dealers. There's one amendment in your voting pack that is SB 345/353-622/1. The amendment makes changes on page 2. And first, that applies to the definition of the definitions applicable. Creates a definition for manufacturer association, which means a business entity that is primarily owned by or composed of manufacturers that collectively represent a majority of the manufacturers in the state and primarily represents the interests of manufacturers. Then in section 15214 of existing law, would add to the changes being made there. I'll just read the entire subsection. It would provide that except as provided in subsection B, in addition to any other right to request a hearing under this subtitle and notwithstanding any provisions of the franchise agreement to the contrary, a dealer, designated dealer, or dealer successor as provided in 15.211.1 of this subtitle, dealer association on behalf of itself, a dealer or a group of dealers, manufacturer association on behalf of itself, a manufacturer or a group of manufacturers, distributor or factory branch may request a hearing under Title 12, Subtitle 2 of this Article 2, and the language that follows is the same. It's got a conforming change.
All right, let me just adopt the amendment first.
Yeah, I don't want to get ahead of that. Is that done?
Oh, yeah, great.
Okay.
And then Senator James.
All right, so having just seen the amendments, I am reading the testimony of, I think, the man behind this push, Mr. Kitzmiller. And this is what he says about the bill before us. This bill does not create a new dealer rights, expand existing franchise, or authorize claims for monetary damages. It does not involve private contract disputes between a manufacturer and a dealer. Instead, it allows a recognized dealer association to seek declaratory or injunctive relief when a manufacturer engages in a practice that violates Maryland franchise law and affects dealers broadly. So the question is that what this bill does?
That's correct. The bill does not neither expands nor contracts any rights of any dealer or manufacturer. It simply makes clear that an association can be part of the administrative process.
Well, he's very specific. I understand this, it says they can't recover monetary damages, and the bill is confined to declaratory or injunctive relief when a manufacturer engages in practices that violate Maryland franchise laws and affects dealers broadly. That is the bill that the man behind this bill wants, and that's what he asked for. That's the paragraph. Does the bill as amended follow and track with this language? That is what he asked for.
Yes, Senator.
Okay. So I'll just, where does the language indicate that it's restricted to no monetary damages and only declaratory or injunctive relief when Maryland franchise laws have been, dealers have been affected broadly?
Sure. So that's current law. And so what?
Where's that? I just read the whole section. I didn't see that myself, that there was only declaratory or injunctive relief and only franchise laws affecting broadly, dealers broadly. Sorry to do this quickly, but I'm trying to go fast to find it.
Yeah, the way that section of the code is structured, so 15.213
Okay, hold on.
is,
I'm going to get it in front of me. Good.
Okay.
I've been reading this statute.
Yep.
Hold on. All right. Yeah, all right. Yes,
So-
yes, got it.
So that's the section of the code.
Yeah.
If you want damages, you have to go to civil court to get damages. So we are not putting dealer association at all in that section of the code. In fact, in the 2024 legislation, that we did have dealer association in there. The House, which passed the bill, because of the manufacturer's concern, took that out so damages would not be pursued or could be pursued. So the only recourse the Dealers Association would have is under the Administrative Procedures Act, and that has got to be, a damage award would have to be expressly permitted in this section of the code in order to be able to pursue it under the Administrative Procedures Act.
I don't, so the testimony written of the Alliance for Automotive Innovation says on the second page, the bill would also allow a dealer association to recover damages even when suing on behalf of a dealer or a group of dealers. It's not clear if the damages are in addition to damages the dealer or group of dealers could recover themselves, or if the association could be required to pay the amounts to such dealers. I mean, that's their language. Yeah. So they read this bill to allow the association to be suing for damage, whether it's on behalf of somebody else. In other words, you know, they're not injured directly. But they're bringing it for a dealer, or it could also be, given their belief, that you could also ask for additional damages based on the association. So are they misreading the bill?
I think they're misreading it, because I think you would have to amend 15.213, which is what the 2024 bill did do, but they removed all of that language from 15.213, and they've limited the only recourse to the Dealers Association under 15.214. And that is only limited to the administrative proceedings.
Okay, so we don't have an attorney general decision, any kind of guidance on this about what, and here's my, let me just put on the record. I think that Maryland's in the right place when it says a plaintiff has to have incurred directly damages and not allow any, third parties generally to come in and stand in their shoes and sue. And there's a lot of extremely important policy reasons for that. But basically, you want to confine a case to an injured party and the person alleged to have injured them. And this would be a detour. And outside of some environmental law, I'm not aware that we have allow in any other way an association to come in, not be the injured party, but pursue a case. And if you start in the APA, you still can go to circuit court, can you not?
Yeah, but the appeal is on the record. So the circuit court can't create out a whole cloth of damage award from an administrative record.
Well, what I'm saying is, if they can go to the APA, I don't know whether it's limited to non-economic, no, not damages. But my point is, if you start in the APA, you can still go to circuit court. And I'm not clear, I don't know if you would allow me to do this, because I would like to get comfortable. I'd like to have some Attorney General tell me whether or not we are opening up a way for non-injured parties to bring lawsuits. Because if we're not, and we're just limiting it, I could, be supportive, but I'm worried about whether or not we have the tightest language. Does that
So
make sense?
I think you and I are saying the same thing. I'd like to press forward that the bill doesn't apply to standing in court. It only applies to standing in the administrative process. And so this is not allowing associations to go directly to the circuit court. They have
do what? Say that again.
It does not allow the dealers or the manufacturers to go directly to the circuit court. This level of standing is exclusively for the administrative process, which is reflected in the title of the bill, right? So it says vehicle manufacturers and dealers, dealer and manufacturer associated administrative hearings. And so I appreciate your concern about standing and real harm when it comes to going into our court system, but this is just for the administrative process that we've already created for this so that these disputes can be resolved
Even
before.
want to do a question?
Yeah.
Do we have this, have we allowed this to happen anywhere else in the Maryland Code does this go on anywhere else in the state of Maryland right now, or is this the first of its kind?
Standing's been granted in Maryland to associations in community nuisance, environmental law, so.
Oh, sure, I get that.
Yeah.
We don't, yes, and that current law would allow the association under the limits, however the court would look at it, perhaps they would vet it, they would look at the totality of factors, but we wouldn't predetermine, regardless of what the factors are, that an association could come in, they'd have to meet Maryland's concept of standing, right? So I'm just trying to figure out if we have codified anything for any other group to not go through that vetting process by a court as to whether or not that association would have standing under our principled approach for the subject.
Well, I think we're kind of saying the same thing.
I hope so.
It's so in this case, the Dealers Association would be able to stand in the shoes. In the cases that I was talking about before under environmental community nuisance, they would have to establish that they represent the community. So there are certain things within those statutes that say this community association can have standing if they do such. And that would be true in this statute as well. You've got to be a Maryland automobile association that represents most of, so you'd have to meet the qualifications in this in order to have standing. So those code sections require those community associations to meet standards. This would also require a dealer association. It's got to be primarily owned and composed by dealers, collectively represent a majority of franchise dealers. So
are you reading this from the amendment? Sorry, is that?
That's actually in the statute or the bill itself. So they would have to at least establish that before they would be able to. So, and so I think it's consistent with those others in that those others say you've got to do X, Y, Z, or be X, Y, Z, I should say. And this says you've got to be this in order to have standing.
And the reason I'm asking all of these questions isn't to, I think the Maryland courts have done a good job on standing, and we have a few statutory situations. I don't want to be vexed by countless associations of all stripe coming to us and saying, hey, if you did it for the car manufacturers, what is the cogent reason we can turn and say, no, we're not going to open this up to any and all other groups? What could we say to the public about why this is an exception and a limited exception?
Yep, it's a limited exception because the dealer-manufacturer relationship when it comes to automobiles is a uniquely state-regulated relationship that has extensive amount of code already existing. So what you're seeing in the bill is word changes to existing regulations. And so this doesn't substantially change that. There is no other industry that is regulated at the state level in the same way as this industry. And so if other associations come back to us that you can say, oh, listen, go litigate it. This is outside the scope of this particular unique regulated industry that has historically been a state-regulated industry.
And I hope that's true. I'm not an expert. I don't have enough knowledge about what other business relationships in Maryland are highly regulated by the state. I have a feeling this isn't the only one, but I can't pull one up and think of it. But thank you all for helping me with the questions. Sure. Okay, thank you.
Senate Bill 345 with the amendments passes 10 to 1. All right, we're now going to move on to Senate Bill 331.
Senate Bill 331 alters the expiration and renewal periods for a handgun permit issued to a retired law enforcement officer who retired in good standing from service with a law enforcement agency of the state or a county or municipal corporation of the state. Under the bill, the handgun permit expires on the last day of the holder's birth month following 5 years after the date the permit is issued and may be renewed for successive periods of 5 years each if, at the time of the application for renewal, the applicant possesses the qualifications for the issuance of a permit. And this is, there are no amendments in your voting packet.
Motion is for a favorable. Second. Is everyone okay being recorded in the affirmative? All right, Senate Bill 331 passes unanimously. We'll now move on to Senate Bill 775.
Senate Bill 775 requires a federal firearms licensee or law enforcement agency that operates a gun buyback program to destroy each firearm, including every component and part attached to the firearm that is surrendered to a licensee or agency at a gun buyback program as specified in the bill. This requirement does not apply if a law enforcement agency determines that a firearm is stolen or is evidence of a crime. A licensee or agency that violates these provisions is subject to a maximum fine of $10,000 per violation. If the violator is a licensed firearms dealer, in addition to that penalty, the Secretary of State Police must revoke the dealer's license. A person may not operate a gun buyback program except in accordance with the above provisions. A person who violates this prohibition is guilty of a misdemeanor and on conviction is subject to a maximum fine of $10,000. A law enforcement agency that receives a firearm as part of a gun buyback program must make reasonable efforts to determine whether the firearm is a crime firearm or has been reported as lost or stolen before the firearm or its component parts may be destroyed. Nothing in the bill may be interpreted as an exception to any other requirement or restriction under state or federal law relating to the purchase, rental, loan, or transfer of a firearm.
The requirement to run a background check and to see if it's stolen, lost or stolen was something that was amended on during the floor debate with the senator from St. Mary's. Senator Fold.
So that's, thank you, Mr. Chair. That's what I wanted to ensure that we had something in there. So I see 5-904. Is that the part that's going to address the part about law enforcement being required to check for theft, NCIC, all that?
Sorry, good. There's been a motion for favorable, he's seconded, but there's questions.
While you're ahead.
He's talking.
I'm still talking. Good Lord. I want to move unfavorable on every one of his bills this year, especially his last one. So reasonable efforts, are we going to, I understand it has reasonable efforts in there, but the part that I want to be sure about is, right, so I want to be sure that reasonable efforts is very subjective. So is there something, is there any appetite to say that they would be required to do a minimum NCIC check, you know, for, at a minimum? I mean, that's all I'm asking for, is that they do, that they'd be required to, because reasonable, I just would like them to ensure that reasonable efforts that at a minimum, an NCIC check is conducted to check for theft or.
You can say that.
Is that,
that's the intent. I mean, look.
I know, but is that amenable? I mean, is that something we can put in there to show that at a minimum, reasonable efforts to, at a minimum, a check of NCIC to ensure, you know, theft or legally ownership or possession at that time or something like that. I don't know if that's the right term, but I don't want to muddy it up too much. I just want to make sure that we're doing a history check of the weapon.
Yeah.
So,
the fire.
Senator, if the committee was inclined to do that, the wording that I might recommend would be to reword 5904, which is page 4 of the bill, between lines 12 and 17, to say a law enforcement agency that receives a firearm as part of a gun buyback program under the subtitle shall make reasonable efforts, comma, including a check of the National Crime Information Center database,
That's all. That'd be
comma,
perfect.
and then the rest of the text.
Including that.
Right.
That's perfect.
That's my intent anyway. I mean,
Yeah, I know it is. I just don't, I appreciate the,
Yeah, I'm down. So you can do the inline amendment.
So, and Sandy, for the record, it's page 4, in line 14, after reasonable, insert, or excuse me, after reasonable efforts, insert comma, including a search of the National Crime Information Center database, comma.
to determine, yes. It's same, it's just clearly spelled out. Thank you.
From the what?
Including a search of the National Crime Information, sorry, it's the National Crime Information Center database.
Okay. Thank you.
Thank you.
Thank you. Now I would like to move the bill with the amendment, unless he's got something to do.
To my sock buddy, thank you. My understanding is of what we've just done, we said if you turn a gun in, they do a check on, they do a check on it, background, whatever. Most buybacks are set up for them to just go, give the gun, walk away, and the incentive is you will not be prosecuted. Now, what if in this buyback, a gun comes back saying stolen? Will they then go back to the person, okay, they cannot do that?
It's a check on the firearm, not the person.
Correct.
Gotcha, okay, that's good, thank you.
Yeah.
There's nothing that says they can't go out.
Okay.
So you,
We also don't want the gun buyback to be a safe harbor to dispose of criminal weapons.
I mean, look, the incentive will have to be, I'm like, I don't want to, you could, their policy could be that they're not going to go,
Correct.
find the person, but I don't want to put that, I'm not touching that.
Correct.
All right.
All right.
All right.
You had a motion then.
So we adopted the amendment. Thank you for the question. It's a very important question, actually. Now the bill's before you as amended. Motions for favorable, it's been seconded. All right, Senate Bill 775 with the amendment passes unanimously. Okay, now we are going to move on to Senate Bill 334.
Senate Bill 334 prohibits a person from manufacturing, selling, offering for sale, purchasing, receiving, or transferring a machine gun convertible pistol as defined under the bill beginning January 1st, 2027, and subject to specified exceptions in the bill. The bill alters the definition of a rapid-fire activator to include a pistol converter. As a result of the expanded application of existing penalty, a violator is guilty of a misdemeanor, punishable by imprisonment for up to 3 years and/or a $5,000 maximum fine. The Department of State Police may adopt regulations to implement the bill's provisions, including publishing a list of prohibited machine gun convertible pistols. There is one amendment in your bill packet. That is Amendment SB 334, 413-621/1. It may be helpful just to go through the bill to tell you where the changes are. First, beginning on page, the substantive changes, beginning on bill page 2 of the reprint, makes changes in additions to the definition section. It adds a definition of common household tool. Means screwdrivers, pipe wrenches, pliers, hacksaws, crowbars, electric drills, rotary tools, hammers, chisels, files, and crescent wrenches. It defines cruciform trigger bar as a component in a semi-automatic pistol that serves as a link between the trigger and the firing pin and has its sear incorporated into a cross-shaped surface. It strikes part of the definition of machine gun convertible pistol. That provision would now read, or that definition would now read, that it means any semi-automatic pistol with a cruciform trigger bar that can be readily converted by hand or by using common household tools into a machine gun by the installation or attachment of a pistol converter as a replacement for the slide's back plate. Going on to the next page of the reprint, this is still technically page 2 of the bill.
Mark your questions as we go through, because he's going to go through it all, and then we'll go back through your questions. Okay.
Machine gun convertible pistol would include a semi-automatic pistol described under paragraph 1, which is the definition that I just read, regardless of whether a tab or other piece of material is located on the rear portion of the pistol frame to block the attachment of a pistol converter, if the tab or other piece of material can be readily removed with a common household tool. It strikes part of the definition of machine gun convertible pistol in paragraph 3 to provide that it does not include a hammer-fired semi-automatic pistol. Moving on to bill page 5, there's an exclusion that's added to provide that the provisions don't apply to a temporary gratuitous exchange of a machine gun convertible pistol. There's also a provision added below line 11 for transfers and receipt by immediate family members. So these would be spouses, children, stepchildren, parents, step-parents, siblings, or step-siblings. It would provide that a person who lawfully possessed a machine gun convertible pistol on or before December 31st, 2026 may sell or otherwise transfer that pistol to an immediate family member who is not prohibited under federal or state law from possessing a firearm. There's a corresponding provision added below regarding the receipt of that firearm. And that concludes the substance of the amendment. I will point out, I had reached out to the Attorney General's office regarding the meaning of the term transfer under the bill. In other provisions of the code, the term transfer does not include loans. That's in the public safety.
Does not include loans.
Does not include loans. So a person could loan their pistol to another person and not be impacted by certain provisions of the public safety article. We're not dealing with those provisions in this bill. My question was, does the term transfer under the bill and in existing law, the provisions of the criminal law article that are being affected, preclude a person from or criminalize a person from temporarily giving their pistol under this bill? And so the AG's response was that it likely would prevent a person from temporarily and gratuitously transferring that pistol, so a loan. So that accounts for the, it did not appear that the intention was to include loans within the bill. So that accounts for the addition of, on bill page
Meaning
5.
that you can loan.
Right.
You know, at like a range or something like that.
Right.
Right, that's
Right. So to be clear, right. So to be clear,
You can do it.
The intent of the bill is evidently, and the language represents that if Chair Smith wanted to loan me his pistol, he could do that on a temporary basis and without remuneration alone.
All right. And then we can work off of the amended bill. Is everyone okay with just adopting the amendment to work off? All right. Now the bill is before you as amended. Discussion. Senator Fulton.
So this is a lot of changes. I mean, from the original hearing these changes there's pretty detailed changes from the original hearing. I mean, is that accurate? I mean, and the reason I'm bringing that up is I would like to have the opportunity to just absorb this and speak with somebody about some of the legality of some of these things. So, I mean, I don't want to belabor the committee's time. I mean, but I would like to be able to give some legal standing on, like, even the transfer part. I mean, not that I don't trust counsel, but this is obviously, we give a lot of latitude for certain interpretive measures. And, and just recently, I will tell you that even though, when the Glock Gen 5 had the issue that they could make it into a convertible by switching the back plate. So Glock on its own decided to make a Gen 6. The Gen 6, it took people less than a couple days to create a new way to combat that, which is already a federal crime. However, the latitude that we've given, the state police took it upon themselves to put the Glock Gen 6, which is a very safe handgun, on the restricted list. So I don't want this to I need time to absorb this and run this by, because I don't understand. I'm still having a hard time. I just found out the other day that the Gen 6 by MSP was interpreted as an unsafe gun, and it's on their restricted handgun list, which is absurd to me. It's one of the safest handguns you can buy. This is seemingly going after those people who are already criminal actors by federal law. So I just need to compare side by side. So with that, I would like to ask the indulgence to be able to hold this and go over that and do that comparative analysis, because this is a lot to bite off here from the hearing to these amendments. So that's why I'm going to respectfully ask for a hold to be able to do that. I'm not trying to delay this. This just came up first time, and I would like the opportunity to have those discussions in a manner that are meaningful and, that are going to be insightful and informative, because again, just 2 days ago, found out that MSP disqualified the Glock Gen 6 on their own. It's not what?
It's a separate issue from what this bill deals with. It relates to the handgun roster.
Yeah, the handgun roster. So anyways, we give a lot of latitude, and this one is so important. I just want to be able to, because it's already a criminal act in the federal, under the federal guidelines. So I don't know exactly what we're trying to do here, but I would like to compare them side by side.
All right, so if we I get what you're saying. So the floor is now, okay, we can come back after the floor, but you walk me through.
I mean, yeah, it's just not just counsel that I need to speak with. I mean, I trust, I don't have any reason to not trust what Jamie is going to say, but I have other subject matter experts that I need to be able to consult with to see what, is there any unintended consequences by the by the deletion of some of this, and then the cruciform trigger bar and the language there underneath that. I just need to be able to speak to the correct subject matter experts. This is a really important issue, and it's a really dangerous slope. I would just want to make sure we're doing this from a correct legal standing.
We will make sure that to the extent possible, you get as much information, and the whomever you need to speak with, we'll make sure we get those people on the phone, if possible, to the extent possible. Yeah,
There's
no.
also a pretty significant floor debate that's getting ready to come up that I'll prep it.
I will make sure you have enough time.
Thank you.
Yeah,
Could I just interpolate the
Yeah.
three Republicans?
And senators are supposed to sit with the Senate president and have a private conversation after the floor today.
Okay, look, we're going
We're gonna
move this
resume
along.
after session.
So, and this is the only topic of business when we come back. So I want to make sure people have time
Thank you.
to walk through, but we'll come back. So I know I don't know how long that meeting's, but you'll have time.
Thank you.
All right, so let's gavel out. We'll come right back after floor, after.